Maitland Local Court aren't handling fresh custodies, but they are still doing bail reviews. Observing bail reviews can give us insights into bail considerations and the decision-making process around bail. It's August 2025 and a defendant who is currently bail refused is asking Maitland Local Court to grant bail. They're coming in via video from Parkley, which is a jail in Sydney. We hear this middle-aged defendant is bail refused on two matters. Today, the defence solicitor will have the burden of persuading the court as it is both a Section 74 and a show cause, meaning it's likely the court has already refused a release application. And the show cause is likely that when bail was granted last time, there was alleged reoffending. Yep, there's a bail history associated with this defendant. However, first we get to hear all about the defendant and the new bail conditions that they are proposing. Beware if you are observing, because you'll hear about the wants and the needs of the defendant a lot, and very little is spoken about the alleged offending or the complainant. But just wait until the prosecutor speaks next. We hear it's this defendant's first time in custody and how they are having to adjust to being confined in jail. They are proposing house arrest rather than jail. The prosecution is opposing bail being granted. Very quickly, the prosecutor sums up the strength of the case, the likelihood of jail, and the risk to the complainant. The defendant was charged with assault occasioning grievous bodily harm in December 2024, where bail was granted. Then, 6 months later in June 2025, when on bail, the defendant is charged with common assault, where bail is granted again. By the way, it's inferred it's the same complainant. Also, it's possible Parramatta was involved in one or more of these bail applications, but it doesn't matter because it's all the local court. So, out on bail again, it's alleged the defendant continues to attempt to contact the complainant, and a month later in July 2025, there's a new charge for stalk and intimidate, where bail is refused. Now it's late August and the defendant is asking the court to grant bail again. This all ends with the magistrate explaining their decision-making process, acknowledging the safety of the complainant and the strength of the prosecution's case, but spending time acknowledging essentially the needs and wants of the defendant. Again, there's a lot of discussion about the defendant being confined in jail, but it's not over until the magistrate says the words. For those reasons, etc., etc., bail is refused. In my opinion, this case shows that bail is being refused if a person allegedly, repeatedly... My God, that was loud. Right when I was getting to the conclusion. In my opinion, this case shows that bail is being refused if a person allegedly, repeatedly assaults, stalks, and intimidates a person. I think we should talk about cases like this more often outside the courthouse.